Welcome to this case explainer, hiding in plain sight, focusing on a Ponzi scheme, the Supreme Court, and the fight for open justice in New Zealand. We will explore the case of UV Limited versus AB Limited, 2026, NZSC 31. The story begins with the collapse of the Penrich Fund. Kelly Tonkin operated a fraudulent Ponzi scheme, which inevitably collapsed. Millions of dollars of investors' money disappeared overnight, leading to Tonkin's conviction for serious fraud. Under the Criminal Procedure Act 2011, the District Court ordered permanent name suppression for the victims of Tonkin's fraud. This protection was extended to innocent investors, the company UV Limited, and its director WX to shield them from public embarrassment. However, an accidental exposure occurred. Following the fund's collapse, Director X made public comments to the media. As a result, both WX and UV Limited were explicitly named in online reports, permanently connecting them to the Ponzi scheme on the internet. This created a new battle: criminal versus civil law. The criminal case saw Tonkin imprisoned and victims receiving name suppression. The civil case involved angry investors suing UV Limited and WX to recover their lost millions. The core legal dilemma arose when UV Limited and WX argued that using their real names in civil lawsuits would break the criminal suppression order. However, they were already named online due to WX's own interviews. The question became, can you legally suppress a secret that is already public? The case climbed the ladder of justice. The High Court refused to hide their names, ruling civil documents didn't breach criminal suppression. The Court of Appeal agreed and dismissed the appeal. UV Limited and WX then took the case to the Supreme Court. The Supreme Court faced two key questions. The first, a criminal law test, asked if handing over civil lawsuit documents constituted a, quote, publication that broke the criminal suppression rules. The second, a civil law test, concerned whether a new non-publication order should be created for this civil case. Unpacking question one involved determining what relating to the criminal proceedings meant. Breaching this rule is a serious offense. Courts must be careful not to interpret relating to too broadly, as suppression limits freedom of expression. The court's analysis found no breach. The references to Tonkin in the civil pleadings were limited. The conclusion was that sharing civil lawsuit documents with third parties is not a report relating to the criminal case, and therefore does not break the criminal suppression order. Addressing the second question involved the principle of open justice. In New Zealand, justice must be seen to be done, prioritizing transparency and freedom of expression. Hiding names in civil courts is incredibly rare, requiring exceptional circumstances. The court applied the, quote, Erceg Test, which requires proving exceptional circumstances for a civil suppression order. UV Limited argued that publicity would hurt them financially. The court ruled that financial impact and reputational concerns are commonplace and not strong enough reasons to hide the truth from the public. The court noted the fatal flaw: the internet never forgets. WX and UV Limited had already identified themselves in media articles. The damage to their privacy was done by their own actions. You cannot suppress what is already public. In the final verdict, the application for leave to appeal was dismissed. The Supreme Court stated the case didn't raise any new questions of public importance, simply applying well-settled laws to the facts. UV Limited and WX were ordered to pay $2,500 in legal costs. This case shows that the justice system distinguishes context, separating criminal privacy from civil transparency. Transparency wins, as New Zealand fiercely protects the public's right to know. Finally, in the digital age, you must think before you speak, because the internet never forgets.